Still good?
Yeah.
Good afternoon and welcome to Children and Family Affairs Subcommittee. Thank you all for joining us today. We're going to begin with Representative Garrett leading us in prayer. We're going to stand and please remain standing for the pledge. You're recognized.
Please bow with us. Dear Heavenly Father, please bless this committee's work today, that we do good work on behalf of Tennessee and Tennessee's children, with all those that are going to be presenting before this committee and all of us as we guide policy for this great state. In your heavenly name we pray. Amen. Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Mr. Clerk, would you please call the roll?
Representatives Bricken, Farmer, Gant, Garrett, Harris, Jernigan, Powell, Stevens, Chair Lady Littleton.
Here.
Chair Lady, you have a quorum.
Thank you. Members, do we have any personal orders? As a reminder for all witnesses before the committee today, you have 3-minute time limit for your testimony. After the 3 minutes, we will open up to member questions and for a few minutes before going on. We have 14 bills today, but we have a little housekeeping to do. Number 2, House Bill 1913 by Representative Boso has been taken off notice. Number 7 by Chairman Reagan has been rolled 1 week. Number 8, 1995 by Chairman Reagan has been taken off notice. Number 10, 2911 by Representative Eldridge has been rolled 1 week. Number 12, 2050, House Bill 2050 by Representative Gant has been rolled 1 week. And with that, takes us back to number 1. House Bill 2936 by Representative Basin. Properly motioned and second, you're recognized.
Thank you, Madam Chair. Committee, very good to be with y'all today. Madam Chair, there is an amendment that writes the bill and several people who'd like to testify on the bill. How would you like to proceed? You want to?
Let's put the amendment on, please.
Okay. I have a drafting code 4446.
Okay.
Second.
Okay, properly motion and second. Let's go ahead and put it on. All those in favor of adding Amendment 14446 to House Bill 2936, say aye.
Aye.
Those opposed, no. The ayes have it. You're recognized on House Bill 2936 as amended.
Thank you, Madam Chair. Members, last year I was in conversations with some friends about the importance of the family and parents, that I have felt like I see society kind of eroding some of the importance of the nuclear family, parents being involved in children. I've seen some of that society kind of eroding that. As I started to look into it, I talked to people, come to find out that Tennessee is not really known for enshrining in law the importance of the family, such as parental rights are involved. The more I dug into it, the more I thought there are ways that we could strengthen our code, our Tennessee code, and put more emphasis on the family and the importance of parental rights. With that being said, I know there are people here for the bill and against the bill, and if it's good with you, I'll step away and let people talk on the bill.
Without objection, we're going to go out of session, and we're going to ask Ms. Connie Reguli to come forward and state your name and who you're with, please. And you have 3 minutes.
Good morning, committee and chairwoman. My name is Connie. Family Forward Project. I stood in courts across the state for 3 decades, helping families weave through complex legal challenges. I'm here to oppose 2936 as written, the Families' Rights and Responsibilities Act, and any legislation that attempts to enumerate parental rights and then provides that the government can slice and dice those rights away without meeting the constitutional burden that a parent must be proven unfit by clear and convincing evidence before the government can intervene. The bill has 2 sections, one creating an entirely new code section, and the second buries rights and exceptions in Title 63, the Health Care Code. First, definitions. The bill defines a parent to include an individual who's been granted decision-making authority over the child under state law. Decision-making means power granted to a non-parent. I assume this was intended for legal guardians. However, a guardian is not a parent. By statute, they are granted enumerated decision-making authority in a court order, and their rights are limited by that court order. Second, the bill goes on to outline all of the exceptions to parental rights. The word unless is used 5 times. And then the slippery slope section of when this does not apply includes that a parent gives a blanket consent or, quote, a government entity or any other person reasonably relies in good faith on an individual's representations that the individual is the parent of a minor or has otherwise been granted authority to make decisions regarding a minor's care under state law, which can roughly be translated in layman's terms as to, oops, that person told me it was okay. And then there is this exception, meaning that there's no parental rights, quote, services provided to or information is received or maintained about a minor enrolled in an institution of higher education or a minor participating in a program for which the minor's parent has consented to the child's participation by an employee of the institution of higher education or other school official, which basically means there's no parental rights if a college is involved. The section under Title 63 includes a whole new exception to healthcare decisions. Here, a person includes, quote, a corporation or any legal entity or commercial entity, whether or not a citizen or domiciliary of this state, whether or not organized under the laws of this state. And parental rights do not apply when, quote, a person participates or assists in emergency care. This is not a bill for parental rights. This is a bill of parental bondage. With all due respect to the sponsor, the bill has too many slippery exceptions to protect parental rights and protect children at the same time.
Thank you for your testimony. Are there any questions? Representative Harris, you're recognized.
First question is, are we still in quorum? Because we've got a lot of people that just walked out.
We're out of session.
Okay, I just want to make sure before I be able to ask. So thank you for being here. And so for the purposes of this, I mean, it is fairly long. But going back to what it is that you just mentioned, what are the points that you think that are harmful to a parent or the parent's rights?
Yeah, so
Ms.
I went.
Regula, you're
Oh,
recognized.
I'm sorry. Thank you. I want to particularly look at this whole unless section about when a parent loses its rights. There's a whole section about law enforcement, forensic interviews, court proceedings, safety demonstrations. One of the big problems is in that section, there's no level of the standard that would need to be present before there was that state intervention. For instance, if a child is going to be forced to engage in a forensic interview or a law enforcement interview, there should be some credible evidence of probable cause of a crime or imminent threat. So, in other words, this just gives us blanket authority without saying that they have to have cause to do it, at least some type of probable cause. The other thing in particular, it talks about forensic interviews with children, and I think that children, it doesn't really provide that children should then have, and the family should have some protection of the child having an attorney or neutral person present while they're being interviewed in a forensic setting, because this could be anything from a 3-year-old to a 17-year-old. And then under the exceptions of academic, where basically consent is not required, it includes academic, extracurricular, et cetera, photo identification cards, things like that. Those clearly need to be with the consent of the parent, especially these days when we know that electronic imagery can go anywhere. That would help.
Representative Harris, you good? Any other questions? If not, thank you for being here.
Thank you. Thank you.
Next, we're going to call up Mr. Jordan Carpenter. If you would come forward and state your name and who you're with for the record, please. Thank you for being here.
Thank you, Madam Chair, and good afternoon to the members of the subcommittee. My name is Jordan Carpenter. I serve as legal counsel with Alliance Defending Freedom. ADF is the world's largest nonprofit legal organization committed to protecting the rights of parents to raise their children without undue government interference. We're committed to this cause because children belong first and foremost to their families. Over 100 years ago, the Tennessee Supreme Court held that the relations which exist between parent and child are sacred, and that parents can't be deprived of the rights that correspond with those relations without notice and upon some ground which affects materially the future of the child. House Bill 2936 provides clear standards in support of these sacred relations between parent and child by defining the right of a parent to direct the upbringing, education, and care of that parent's child, declaring that right to be fundamental, which means that government interference with the right gets the highest level of scrutiny, and providing a legal remedy for parents whose rights have been violated. Because it is fundamental, the right of fit parents to bring up their children as they choose should receive top-tier protection from all levels of government. But ADF represents and has represented parents in Wisconsin, Michigan, Virginia, and other places where government officials have hid information, lied to parents, or otherwise interfered with the realm of authority that rightly belongs with the family. And while Tennessee has a historically strong record of protecting individual liberties, the state lags behind the 17 other states that have codified the fundamental right of parents to direct the upbringing, education, and care of their children. Passing House Bill 2936 would put parental rights at the top of the priority list in Tennessee. Because parents know and love their children best, the government's role should be to defer to parents except in extraordinary cases. In 2013, the Tennessee Supreme Court reaffirmed its commitment to parental rights when it said, "A parent's right to the care and custody of his or her child is among the oldest of the judicially recognized liberty interests." By passing House Bill 2936, the General Assembly can do its part to prioritize and protect parental rights in Tennessee. Thank you for the opportunity, and I'd welcome any questions.
Thank you for your testimony. Representative Harris, you're recognized.
Thank you, Chair. So with that, what about the kids that would be in DCS custody?
Mr. Carpenter.
Representative, that's always the question, right? Government has a role to protect the rights of parents. It also has a role in protecting the safety and well-being of children. That is a foremost consideration, and that's what these standards are for. That's why the balancing test, it's why some of the exceptions that the previous witness talked about exist in the bill as drafted, because there's always a balancing act between the rights of parents and the responsibility of the government to ensure that children are not abused or neglected.
Representative Harris.
So if a child who has been in a situation where they may have been neglected in some form, reading this, unless there's somewhere else that I'm not reading, based off of it, it looks like the parent will still have the full rights as far as like the moral and religious training for the child and to direct the upbringing of the child, even if DCS has custody of that child.
Mr. Carpenter.
No, and I think that's where we talk about unless otherwise provided by law or court order. And there are plenty of places in the Tennessee Code where already parents' rights are infringed on based on circumstances relating to the child and preventing things such as child abuse or neglect. Now, it's kind of baked into the system that those things have been built based on the standards that this bill would codify, which is there's a compelling governmental interest and the government's actions are narrowly tailored to serve that compelling interest. So as an example, there's a compelling governmental interest for Tennessee to prevent or address child abuse and neglect. It will use the means that it has through the court system, through other government activities to address that. Now it just has to tailor those activities and those policies to make sure that it's serving the interest and not doing something else or otherwise unduly interfering with the parent's right.
Representative.
So from a DCS standpoint, If a child is in this situation here where we'll have one law that says that they have the rights to all these parental rights, but then we'll have other laws. So basically, a child will be in a court battle going back and forth because one party is going to sue DCS, and then DCS is going to be taking the parent to court, vice versa, based off of this legislation. So we're just going to have just open cases just going back and forth.
Mr. Carpenter.
No, I think this bill simply codifies what already exists at common law throughout the state and federal court systems. So the interactions with the state that parents already have through DCS or child welfare cases within the custody battles, all of these standards are already built in. And so they can make those arguments in court already. But this provides an avenue for parents who feel like their rights have been violated. Maybe there's not already a case pending against them, provides them access to address those violations in a way where clear standards are set and parental rights are prioritized in this state.
Representative.
So I guess my last question is, and I was talking about this earlier, but the parent still has these rights until the court rules otherwise. In a lot of cases, and here I'll use, for example, on number 8 says that the parent has the right to participate in parent-teacher association and school organizations that are sanctioned by the Board of Education of a local education agency. So I still, even though my child is currently under custody with DCS, I'll still have the right because of this law to be able to go to parent-teacher conferences, to do all the stuff I would like to do with my child, even though my child is technically in the custody of the state.
Mr. Carpenter.
Thank you, Madam Chair. Again, the many of the enumerated rights here, it's the consensus view of what the parent's right to direct the education of the child, for example, is. So the right to direct education is the right to choose the setting where your child is educated, to participate in the academic process, and to make reasonable choices within the curriculum setting. So those things are already in the system. They already have case law that support those things. This is simply laying it out in the Tennessee Code to say the legislative branch is not only endorsing this, but saying this is what we want to be the public policy of Tennessee, not subject to judicial interpretation.
I don't have anything else, but I do think that this will probably cause some headache for DCS for sure. I don't know if they're speaking on this, but definitely would have some questions for them if they're not.
Representative Bricken, you're recognized.
Thank you, Madam Chairman, and those are awfully good questions. So, background, what organization again are you with?
Thank you, Madam Chair. Yes, sir. I work for Alliance Defending Freedom. I'm an attorney.
Okay. So ADF is your acronym, or?
Yes, sir.
Okay. Are y'all the source for this legislation?
Mr. Carpenter.
The source of the legislation is obviously with the sponsor. I have worked with the sponsor to ensure that we work within the function, the structure, even the syntax of the Tennessee Code, that it doesn't conflict with laws as they currently exist. So I wouldn't say we're the source, but we definitely have worked with the sponsor.
What?
Representative Bricken.
Thank you, Madam Chair. You mentioned 17 states. Have they passed similar legislation as being proposed?
Madam Chair.
You're recognized.
Yes, sir. So 17 states have codified and used the words that the right of a parent to direct the upbringing, education, and care of that parent's child is a fundamental right.
No, and that's not a
Representative
question.
Bricken.
Thank you. Has 17 states passed legislation directly like this? And almost, is this a uniform type of legislation that your organization is sponsoring across the nation?
Mr. Carpenter.
It is substantially similar to those other 17 states. Yes, sir.
Okay.
Yes, sir.
Representative Bricken.
And when was the earliest of that legislation enacted in any other state?
Mr. Carpenter.
Many of the states have had statutory language that's substantially similar to this on the books for decades. Colorado is a good example. Even West Virginia has a statute that harkens back to 1870. So there are some statutes on the book. A lot of the parental rights litigation arose in the 80s and 90s when states were passing grandparent visitation laws or other things that infringed on the rights of parents. That's when a lot of the lawsuits dealing with this issue. And then since I'd say the 90s, states have considered this type of legislation. I'd say the bulk of those 17 states have passed their legislation in the last decade.
Okay.
Representative Bricken.
That's kind of, I mean, I kind of wanted to get a little bit of the historical possible background of this type of legislation, because is I'm going to say, as well-meaning as this is, I think we all want to certainly support the family rights and rights of parents. It's just hard for me I'm going to say, to believe that we can cover all the issues in legislation, and therefore we will be continually adding to this or striking from this as we go forward, which may be what we're supposed to do up here. It just seems, I just don't know how we codify everything under the parental rights that we probably need to. So that's more of a statement.
Might I respond to that, Madam?
Yes, you're recognized.
So the broad language is taken from court decisions that discuss parental rights. And a lot of them, the earliest cases have to do with the government taking people's children. Then later on has to do with the right to educate your child the way you see fit. And like I said, there was another spurt of activity with grandparent visitation laws. But the wording has remained consistent from the U.S. Supreme Court and state Supreme Courts for over 100 years. So that's the broad language. There is a little bit more filling in of the lines, I guess you could say, with the enumerated list. But it by no means is it exhaustive, or does it intend to be exhaustive to say this is a list of every single right that a parent could claim under this statute or under the principles that have been used to defend parents' rights in the last century. But it does provide a nice framework to say this is what is clearly the public policy of Tennessee, what we support parents' rights to do in our state.
Any other questions? Representative Carriger, recognized.
Thank you, Madam Chair. I'm trying to review, as you've been discussing this particular piece of legislation, I got kind of several questions. First of all, the Parent Code of Conduct or Family Rights and Responsibility Act, that sounds fabulous. We all want to be able to be free of any government interference on how we raise our children. So I think the concept is certainly admirable, and I appreciate your organization doing that. But there's several parts of this legislation that I'm not really even sure what it means. Okay. But before I get to that, can you tell me a specific incident in Tennessee that you're aware of where either the government entity or a healthcare provider that you're opening up a direct action against under this bill? So it's not just codifying what's already there. I mean, we've got some actions here that a healthcare provider can lose their license. You can have a direct civil action against them. There's a lot of things in here that's creating causes of action that's not particularly just out there right now. So to broaden the ability to sue, what has happened right now in the state as an example to a parent that you know, or that we may know, that this has happened to, that there's a real example out there that's saying either the government in their form of making sure we protect parents and protect children, or there's an entity out there that's violating someone's rights right now to parent their own children?
Mr. Carpenter.
Yes, as I said, ADF represents parents across the country where this has been the case, where mainly school employees have violated the rights of parents. Personally, I grew up in Shelby County and spent most of my life there. I have personal knowledge of non-public instances where this has happened as well, where a teacher has said, I'm going to talk to your parent in the next few days. Should I be using your given name or the name you've told me? which pronouns, what should we be talking about? Are there topics of a conversation that I should or should not cover with your parents? That's the type of thing that a parental rights law that's clear and sets clear standards would address. Not only because it would open up a right to sue the school district for either having a policy that allows for that or not stopping their employee from doing something like that, but also because it reminds the government employees what their role is and what rights parents do have, so that as they interact with other people's children, they don't assume responsibility that they haven't been given.
You're recognized.
Thank you. So just for instance, if, and I'm going to be very simplistic, I'm not going to get into the pronoun argument, but if my son is named Jackson and a teacher wants to call him John, and that offends me because they're not calling him by his given name, your legislation would give rise to me suing that teacher directly, personally, in her personal capacity or their personal capacity, for violating the given name that I've given my son or daughter. Is that the intent of a parent code of conduct, where if something simple like that, where his name's Jackson, but they won't call him Jackson, they'll call him John, that I can sue that teacher or that entity or that person directly? Is this what the intent of this legislation provides?
You're recognized.
I would say under those set of facts, no, that's not what this intends. And the legislation as written doesn't decide, well, a parent's unreasonable claim will win in court, or the government's claim will win in court. It simply sets clear standards. So the parent would have to articulate what right they're looking for. I want my son to be called Jackson rather than John. The court would evaluate whether that's a reasonable claim under the standards of the law, and then people would present proof, obviously. But I think that that seems like a rather minor topic, but that's not what we're dealing with. We're dealing with government entities, agencies, institutions that actively hide or otherwise lie to parents about their children, and meaningful things. Not, here's what I'm calling your son or daughter, but is your son a daughter? And those are things that parents shouldn't be left out of. And those are issues that give rise to legislation that protects parents' rights.
You're recognized.
Thank you, Madam Chairman. And I think you somewhat proved my point. I purposely came up with a pretty simplistic example that can be captured under your piece of legislation that would give someone the right to file that action, which it's relatively minor. That's one of my concerns with the way this has been drafted. And I'm going to quote a sentence under 36.8104, where you provide certain rules should be followed, and you're providing the judges certain instances, either one at the trial court level, or if and when this is ever challenged, what they're supposed to do as it relates to analyzing the constitutionality of this particular piece of legislation. In number 3, it says if a child has no affirmative right of access to particular surgical, medical, or mental health procedure or service, then this act does not grant that child's parent an affirmative right of access to that procedure or service on that child's behalf. I'm going to be honest with you, I don't even know what that says. I don't know what an affirmative right of access to a particular surgical, medical, or mental health procedure for the right of access for a child. So you've got some strict ways to enforce this or follow the rules, but yet the words that are written here are very hard to determine what the legislation does. Do you see that as being a problem with this, or is that something where I'm just not reading into the language? And it's throughout the language. So I want to make sure that if we're going to get a parent right of or a parent code of conduct, or how you've named this piece of legislation, that it can withhold some issues if it's ever challenged. Do you see that paragraph and can kind of explain to me what that means?
You're recognized.
Sure. There are plenty of things that the state of Tennessee has said are off limits for children, whether it's alcoholic beverages, lobotomies, tattoos, or as a concrete example, what this body passed into law last year is a transition procedure or hormone blockers or wrong sex hormones given to minor children. Well, there are arguments out there that parental rights, the right to direct your child's care, would open up that avenue to say my right as a parent trumps the government's responsibility to protect children from harm done through experimental, dangerous, harmful medicine. This makes clear that that's not what this legislation does. And it says in Tennessee, not only is there a limit to parental rights, but the government's reasonable regulation of medicine doesn't even impact parental rights. That's what that language says.
Those are all my
Yes.
questions, Madam Chair. Thank you.
Any more questions? Seeing none, thank you so much for being here.
Thank you.
I think DCS wanted to test.
Oh.
We can go back into session if you want to. We're back in session. You're recognized.
Madam Chair, hearing some of the questions, I'd like to request a roll for 2 weeks so we can get some clarification. on some
Without
stuff.
objection,
Thank
roll
you.
2 weeks. So next we have item number 3, House Bill 1808 by Representative Butler. Properly motioned and seconded. You are recognized, Representative Butler.
Thank you, Chair Lady.
And I see you have 2 amendments.
Yes, ma'am.
Do you want to go through with both of them?
We need to attach 013997. That will make the bill.
Okay, do we want to go ahead and? Okay, the amendment, it's been motioned second. All those in favor of adding Amendment 13997 to House Bill 1808, say aye. Those opposed, no. The ayes have it. You are recognized on House Bill 1808
Thank you, Chair Lady and
as
committee.
amended.
This legislation is to allow a juvenile court that has found substantial noncompliance by the parent or guardian with a permanency plan for within 90 days for them to file a TPR, or termination of parental rights. And so the reason for legislation such as this is to eliminate the roller coaster that many times happens with a child that has been removed from a home, and the parent is required to meet a certain number of parenting classes or whatever the case may be, and they comply with a handful of those, but never really comply with all of those. And in some cases, the child ends up going back to the family and within 6 months is removed again, which is not providing stability. And so the child ends up traumatized further because they don't have the stability that they need for their well-being. And so this will allow a court the opportunity to order DCS to file a TPR, and they would have to comply with that within 90 days. With that, I'll stand for questions and renew my motion.
Representative Harris, we have someone to testify. Do you mind waiting until afterwards? Okay, thank you. So without objection, we're going to go out of session. Mr. Chad Farley, if you would come forward and state your name and who you're with, please. And you have 3 minutes once you start. Make sure your mic is on, please.
Can you hear me?
Yes, you're recognized. You're recognized. You have 3 minutes.
I am Chad Farley of Morgan County. First, I want to apologize to this committee for becoming overwhelmed with emotion when I speak at times. My family's personal experience with DCS and my traumatic brain injury from my service make it difficult to express my thoughts at times. However, I have earned the right to stand or sit in this house before this committee and have my voice heard. I have skin in the game. My voice is important because I know that there are thousands of other families in Tennessee that have been affected by DCS, and they are unable to be heard. I oppose House Bill 1808 until our constitutional rights are recognized by keeping the burden of proof on DCS, the accuser. The rights of countless veterans have protected with integrity and selflessness should have protections. DCS needs to be held to the same level of integrity, along with using the reasonable efforts to avoid family separation. If you haven't caught on by now, my family was targeted by DCS, not because of child abuse, drug abuse, or homelessness, but because my wife, who was at her lowest level in life was taken advantage of while suffering acute psychosis from COVID. In 2021, DCS took my 10-year-old child without a court order and held a meeting to form a perm plan while my wife was hospitalized and unable to attend. Then they did not even give us a copy of the written document until nearly a month later. It took another 2 months before they lined up the required services, which consistently fell through the cracks. Remember, all of this was done before I had even had a trial on the allegations that we neglected our son. Kind of like putting someone on probation before they've even been convicted of a crime. We did everything DCS said by August, but instead of allowing our son to return home, DCS used the case and drug it through the court system and didn't even give us the 30 days. My son slipped me a message during our very first supervised visit begging for help. We felt helpless. My son was not the same when he came home. He was withdrawn and isolated for the next year. We have slowly integrated him back. My son became a statistic for DCS, another child they could monetize in the foster care system. Until you hold DCS accountable for doing their part, you should not pass this bill, which is giving them even more power. Thank you.
Thank you, Mr. Harley. Are there any questions? I think Representative Harris, did you have a question? Oh, that was for the, okay. Does anybody have any questions? Seeing none, thank you very much for being
Thank you.
here today. So with that, we're back in session. Representative Butler.
So
Representative Harris, did you want to
if
speak
I may,
first? You
Madam
may.
Chairman,
You're recognized.
this legislation doesn't give DCS more power. It allows the juvenile court to make that order, not DCS. So with that, I stand for questions.
Representative Harris.
I think which bill we were on.
1808.
Oh, yes. Okay. So what is currently in place right now? How long does DCS have to start the termination?
You're recognized.
Thank you, Madam Chairman. Right now, there's nothing really in place like this. And originally, as I had it drafted, the 90 days was 10 days. And at the request of the department, we've adjusted it to 90 days at their request. So there's really nothing in place right now to address this particular issue.
Representative Harris.
Do you think the courts make a pretty fair decision on how fast it should be right now?
You're recognized.
Well, this was actually brought to me by a juvenile judge that had some situations with DCS, and he said, we need to see if we can fix this. And so that was the genesis of this bill, was a juvenile judge who wanted some timelines put on this. So if he or she or the court ordered a TPR to be filed, that it would be done in a certain amount of time. And I've had one particular instance in my district that was over 13 months and it still wasn't completed.
Representative Harris.
And what reasons did it go from 10 days to 90 days?
You're recognized.
I did that at the request of the department, kind of as a compromise to work with the department in their request. And so I agreed to the 90 days instead of the 10 days.
Representative Harris. Any other questions? Representative Garrett, you're recognized.
Thank you, Madam Chair. And I apologize for this question. Which amendment did we put on the bill? I got 915 or 997?
997.
997.
Mhm.
Okay. Thank you for that. I appreciate that, Madam Chairman. Representative Butler, I think Representative Harris asked one of my questions is, can you substantial non-compliance by a parent or guardian with a statement of responsibilities and a permanency plan? So they violate that, right? Can you describe for me what that is when the court enters in one of those? What are the details that are in there? Because here's my question. I mean, obviously there's statutory factors to terminate someone's parental rights, right? We want to make sure that all those are evident. And they typically are evident if you violate this particular permanency plan. So I want to make sure we know exactly what that is. So if you could describe what that order comes from the judge, and then once the parent violates that, I'm a little bit concerned about putting timelines on lawsuits, right? Which is what this is. So I just want to understand the genesis of this, and then making sure 90 days just wasn't poof. That's what we're going to do, right? I want to make sure kind of what the reasoning is for that 90-day window. So if you could elaborate on that, I'd appreciate it.
You're recognized.
Thank you, Chair Lady. So let's just use, for instance, there's 10 requirements that are outlined in the permanency plan. Parenting classes, might be counseling, anger management, whatever those requirements are. And that's typically going to be outlined in that permanency plan. And let's just say, for example, that the parent complies with 3 or 4 out of 10. And they're doing good. They're making progress. And DCS decides that we're going to place the child back in that family's care. And they don't follow up with the other 6 items. So now a time goes by, and let's say in 6 months, they remove the child again because they're abused or whatever the case may be was for the original movement. That is what this is to address. It's to stabilize the child, because if they're going back and forth from mom and dad or mom or dad or wherever the situation may be to a foster family, that instability is detrimental to the child. So that's what this legislation is trying to address, is to say, hey, enough's enough. We've given you 12 months, for example, to comply with these 10 requirements. And after 15 months, you've only complied with 3 of those. So at some point, where have we given the parents the opportunity to rehabilitate themselves? And so this is not DCS. This is a court of law that's making this determination, not DCS. The court of law would order DCS or instruct DCS, hey, go ahead and file TPR. So I want to make sure I'm clear that this is not DCS making these decisions. This is juvenile court.
You're recognized.
But I think that was fantastic. Thank you for that answer. You did a really good job. I don't want to ask you this question. So if it's okay, Madam Chair, I'd like to ask legal this particular question. I do think it's a legal question that I don't want to put him on the
Okay.
hot spot there to answer
Without
this question.
objection, we will go out of session, and Ms. Sonia, you are recognized.
Thank you
Oh, we
for
did
that.
the question, I guess.
Can you answer for me what substantial noncompliance is under our statute? So we'll know, because I mean, we're beyond that point. This obviously doesn't address that. So I just want to be clear. I get that if you got 10 things you got to do and you only do 2 of them, that would be my consideration. You're not substantially complying with that order. But I just want to make sure to see how that's defined. If you could possibly provide me some insight on what we determine, or what the court's going to determine, what is substantial noncompliance. I hope I didn't put you on the spot.
Elizabeth and Sonia Legal Services. I don't think we have a statutory definition for substantial noncompliance, so it would be up to a court to determine what is substantial noncompliance.
Recognized.
So in regards to a permanency plan that's subject or in front of a judge to decide, is that based upon case law? I mean, what does the judge go by currently if it's not defined as substantial noncompliance? How does the judge know what that means?
Generally, for statutory interpretation, they would look to the plain and ordinary meaning of a term, and there very likely is case law that they can look back to and rely on for how previous courts have interpreted it.
And again, to use his very good example of 10 factors under a permanency plan that doesn't happen, if there's only 2 of them being complied with, from all purposes regarding this bill and the intent, I would consider that a substantial noncompliance. Would you agree with that?
I don't want to get into statutory interpretation that I would find, but I think so. I think it just would be up to a court to look at the entire circumstance of the situation and make that determination.
Thank you very much. All right, that's all the questions.
Are
Thank
there
you
any
for
other
that. Thank you.
questions for legal? I want to ask, right now, when a judge decides about the permanency and the rules, where does that come from? Is there a standard, or is it DCS policy, or is it in code? Law code?
Where does the permanency plan come
Mhm.
from? I believe you might want to talk to DCS about that. I believe that DCS helps develop it, and then the court enters the order, but I would defer to them on how
Okay.
that's developed.
Thank you. Any other questions for legal? If not, we're going back into session. Any questions for Representative Butler? You're recognized.
All right, thank you, Chair. And so going back to what you said, you were saying it as if, maybe I'm looking at it differently, but if the individual fails the first time, like at the plan, this isn't towards that. This is on for future instances. This isn't just the first time that something happened. Because you were like, they go back into the family's home and.
You're recognized.
Thank you, Madam Chairman. So let me kind of address this permanency plan is determined by case managers and judge and attorneys and there could be some psychologists or psychiatrists. There's probably in most cases there's a team of folks that determine this permanency plan, and then the court issues that order to comply with that. So some of these permanency plans could be 18 months long. Some of them could be 6 months. It's all going to be particular to the situation at hand. So this is to address an ongoing problem where we have children that are bounced back and forth because the parents are not complying. So, and I'm not an attorney, so substantial non-compliance is 2 out of 10 items. They've only completed those items. So this could be the first instance to answer your question. It could be the 4th instance. It really depends on the specific situation that this is addressing. So if they've been in there and they've complied with, let's say they complied with 8 of the 10 items, and the child is returned, and 6 months later, DCS steps in, removes this child again, and they say, okay, you've got this new permanency plan, and you only comply with 2, then you're not complying. So it's really on a case by cases to specifically answer your question.
You're recognized.
So currently, a judge can already do that. They have the ability to do it, and so this is just putting it into writing that they.
Recognized.
Yes, that is correct.
Okay, and then
You're recognized. Mr.
thank you, Chair. And then my last question is, or I guess statement more so is, I have a constituent who is actually going through this process now. And they have complied and done everything that's in their plan except for one thing. And that one thing is because technically they were told to get a psych evaluation. They got the psych evaluation already. I think what we're on DCS side have asked that they get one done by DCS, which is not part of what the plan says per se. Could the judge then look at that and say, oh, well, you didn't comply with your permanency plan, even though they technically did? It's just that one thing. Could that be looked at as substantial? Because that's a big piece to a lot of the plans, is that evaluation.
You're recognized.
Thank you, Shirley. That would be up for interpretation of the judge. My personal opinion, to answer your question, if they've complied with 9 of the 10 items, I would think that they are complying. And I think a judge has got to look at a case-by-case basis. What have the parents done? What classes have they done? What requirements have they met? So I don't know in that particular situation, and don't really want to say one way or another without knowing all of the specific details. Because unfortunately, in these situations, sometimes they're very complex because there's so many pieces and parts that are involved. And so I would think that they have complied, but I'm not an attorney.
You're recognized.
And because of that complexity of that is why I can't support the bill in this language, because every situation is different. And I do think that the judge should still remain able to make those decisions as they already are making. And I don't know what was holding up the judge that you're speaking of from being able to do that part in the plan, but it's already there for them to have that ability to do. And I think limiting them and telling them they only have a time frame is going to be harmful in the end, especially when these cases can get very, very lengthy. They are some lengthy cases. I mean, some of them that you would think are going to be short really do turn out to be very long cases. And so I think that this hurts the judge's ability to just do what they're already there to do. So thank you.
You're
Thank
recognized.
you, Shirley. This legislation, though, is to put a timeline on the department, not on the judge. The judge, if they order it, if they've not been compliant substantially or been substantially non-compliant, this gives the ability for the judge to say, okay, Department of Children's Services, you need to do X, Y, and Z, and then the department has 90 days to comply with that. Because right now there's no limit on it. So it's really holding DCS accountable.
So the judge cannot do that already currently.
You're recognized.
Thank you, Chair Lady. Not under these circumstances. I mean,
Thank you.
Any other questions? Are we ready to vote? Without objection, we will be voting on House Bill 1808, moving out to civil. All those in favor say aye. Aye. Those opposed, no. No. The ayes have it. If you want to be recorded as a no, please see the clerk. Okay, now we're ready for number 4, House Bill 1815 by Representative Butler.
Thank you, Madam Chair. I would ask
We need a
that,
motion and a second.
oh, I'm sorry.
Properly motion and second, you're recognized.
I would ask that HB 1815 be rolled 1 week and also HB 2045 be rolled 1 week.
Without objection, we will be rolling House Bill 1815 1 week. And without objection, we will be rolling House Bill 2045 1 week. Thank you
Thank
very
you, committee.
much. Next, we have Representative Cochran. Thank you for being so patient with us today. You're recognized on House Bill 2537.
Thank you, Chair Lady. And we've got an amendment that rewrites the bill, I think. That's right. Yes, and we've already talked about that. And if the committee's comfortable, we can do that in full. I'll go ahead and explain if it's okay with the Chair Lady. I'll explain what the bill does now, and I'll tell you what that amendment will do. It's not very set.
Does it make the bill? Let's just go ahead and move forward with the bill.
Sure.
Okay.
That's perfect. So thank you again, Chair Lady and Committee. I think this one's going to be pretty easy. This adds, obviously, there are a number of elected officials currently who can perform a marriage ceremony. County commissioners, mayors, the General Assembly. This adds district attorneys to that and former district attorneys. This makes them similar to the General Assembly in that you opt in. As members of the General Assembly, we don't automatically have that. We notify the Department of Vital Records and say that we would like to opt in to be able to do that. This would make that possible for district attorneys and former district attorneys. And I'll yield to any questions.
You're recognized.
So I've got no issues with that, but can you explain, so do we adopt the amendment, or is this what the bill is actually going to do, or is it remake the bill? Could you speak to that?
Sure, absolutely. So the bill will remain the same. What the amendment does, when it was originally drafted, we had current and former DAs in the original language, but the way that it was written, it would be former DAs after the passage of this bill. So like if you had been a district attorney in 2010, you couldn't opt into the program. So the amendment addresses that issue.
Okay, thank you for the clarification.
Absolutely.
Okay, I need to clarify that we have not adopted the amendment.
Correct.
Because it was improperly filed.
That's right.
So, but we were just going to move it on and put the amendment on in full. But you're recognized, Chairman Farmer.
Thank you, Madam Chair and Leader Cochran. Appreciate you bringing this piece of legislation. Just bit of housekeeping here, and I think I know the answer, but I'm going to ask it anyways just to clear it up. Does this bill just apply to elected district attorneys, or does this also apply to the assistant district attorneys that work beneath them?
You're recognized.
Thank you, Chair Lady. It be my intent that it elected district attorneys.
Okay, thank you.
So, Representative Garrett.
Well, parliamentary inquiry, I guess. Was the amendment late filed, or just not?
It went to the wrong email
Oh.
at the beginning, and then
Okay.
so it made it late.
Gotcha.
So,
I was going to make a motion to take up the late amendment if that was
Well, if
appropriate,
we-
but it's not. We don't have to do that.
I'm at the will of the committee.
As am I.
Can I do that? Okay. All right. To clarify, it emailed to the right email, but it was late. Okay. So if we would like to take the amendment up, I'm open.
I move to take up the late filed amendment.
Any opposed? Question on the amendment?
On the amendment.
Okay, pardon? Okay, so all of those, pardon? The amendment number, please.
Yes, ma'am. 013859.
Okay, all those in favor of adopting Amendment 13859, please say aye. Aye. Those opposed? The ayes have it. You, all those in favor of, the question's been called, any objection? Hearing none. All those in favor of House Bill 2537 as amended, moving out to civil full, say aye. Aye. Those opposed? No. The ayes have it. Thank you very much.
Chair,
Move
Lady
out to
Committee, thank
civil.
you very much. I appreciate you.
All right. Okay, so now we're on number 9, House Bill 2780 by Representative Parkinson. Properly motion second, you're recognized.
Thank you, Madam Chair Lady. I'll go ahead and take that question if you want to give the question. Make the question. Thank you, Madam Chair Lady in committee. Last year we passed a law that defined parentage fraud, and what this bill does, it says if anyone is
Oh, and you do have an amendment, is that correct?
oh yes, ma'am. I'm sorry. Yes, ma'am. I do.
Well, let's see what he has first.
I have 013993. Is that what you got?
That is it.
Yes,
Okay.
ma'am. And it rewrites the bill.
All those in favor of adopting Amendment 13993, say aye. Opposed, no. The ayes have it. You are recognized on House Bill 2780 as amended.
Thank you, Madam Chair Lady. Last year we passed a law defining parentage fraud, and I'm paraphrasing. I would rather have legal explain this, but I'll be happy to explain it. That somebody intentionally says someone's the parent of a child, and they sign on the birth certificate, but they knew that that person was not that child's actual parent, and so what this bill does, it says that if a person is convicted of parentage fraud, the judge and jury may ascertain the value of any child support paid by the victim based on the parentage fraud, and the court must order the defendant to pay restitution of that value of child support back to the victim if it hadn't already been done.
Any questions for Representative Parkinson? Mr. Garrett, Representative Garrett, you
Thank
are
you.
recognized.
Couple questions. Well, I do believe I can ascertain what parentage fraud is. Can you tell me what you think that is, or is it defined in the code already? But can you elaborate on what that is?
Yes, sir. I'll actually, if the chair lady doesn't mind, allow legal to
You're
define it.
recognized.
It's in the code, though. Okay, yes, sir.
We're going to go out of session and talk to legal. Ms. Insania, you're recognized.
Elizabeth and Sonia, Legal Services. Parentage fraud was enacted last year, and it is committed when a person seeks to legally establish another individual as the biological parent of a child in the person's custody with intent to deprive the individual of property or to prevent the child's actual biological parent from exercising parental rights to the child, and the person knows or reasonably should know that the individual is not the child's biological parent. So that's one way to commit it. There's another way, which is to seek to be legally established as a child's parent based on the person's status as a biological parent of the child when the person knows or reasonably should know the person is not the child's biological parent.
Okay. Thank you for
Any
that.
more questions for legal?
I don't believe so, but I do have a question for the sponsor.
All right, so we're going, without objection, we're back in session. You are recognized, Representative Garrett.
Thank you, Madam Chair. I'm looking at Section A of the bill, and it says that the court must order the defendant to pay restitution of that value of the child support to the victim if not previously restored to the victim. Well, I would 100% agree with that, but do we know how to calculate that? What that amount would be?
Representative Parkinson.
Thank you, Madam Chair Lady. That would be up to the judge to calculate that. We're not binding the judge to how he calculates it.
You're recognized.
So this is in a sense of a civil suit that someone has filed against the parent that's committed this fraud?
Yes.
You're
Okay.
recognized.
I'm sorry, Madam Chair Lady. Yes, but yes.
Okay.
You're recognized, Representative Garrett.
That's all. That was I think I'm clear. Thank you.
Thank you, sir.
Representative Powell, you're recognized.
Sounds like a good bill. Quick question for you, Representative Parkinson. The victim, that victim would be the child, correct? Could the victim also be another guardian if they weren't getting the correct amount paid to them, or is it specifically for the child?
You're recognized.
Thank you, Madam Chair Lady. The victim is the person that the parenting fraud was committed against. Let's say on one side that a mother told a guy that he was the father, and she knew that he was not in actuality the father, and that parenting fraud was committed. And so he would be the victim. The other side could be the other father, who, if the father, based on the second definition that legal gave us, if a male signed on the birth certificate knowing that he was not actually the father of that child, then the other victim could be, if there was some money paid, could be the actual biological father.
You're recognized.
So to be clear, so the victim is not necessarily a child. It would be, in this circumstance, the other
Yes,
per
the
parent.
other adult. Yes, sir.
Thank you.
Representative Garrett.
Thank you for your indulgence, Madam Chairman. I'm sorry that you're going to come back to me, and this may be directed at legal, but I want to make sure one thing that came to mind for redress for someone that's been convicted of this, or at least the parent that's been convicted of this, is I don't see where the minor, if it's a minor child, who could bring the suit on behalf of the minor child to collect this particular restitution that we're talking about. And I guess my question may be more directed towards legal, is that I'm assuming that this has already been, I'm assuming that the action already exists, that you're not creating an action in civil court to pursue someone for restitution, because, or is the judge in the criminal court matter, since this person was convicted of parentage fraud, ordering restitution on that person? I guess I'm a little bit unclear on where we are. So I don't know, Representative Parks, is that for you, or maybe a question for legal? But so
Well,
two parts. Let me
let's
make two parts. Is what if the person's a minor that needs to bring an action on behalf to get restitution? I don't see where this addresses someone that's a minor. And then, is it the criminal court judge that's making this determination, or is this a separate civil lawsuit or separate civil action that we're creating in the civil world?
Let's go out of session and hear from legal.
So the Elizabeth and Sonia Legal Services, the way the bill is drafted right now, I think it's two things. One is a restitution order that would be by the criminal court. And then another is creating a civil cause of action to recover. And I think as far as the restitution is concerned, the victim there would be someone who paid child support in reliance on the parentage fraud. So that's going to be the person who either did a voluntary acknowledgement of paternity based on, in reliance on someone telling them you're the biological parent, or entered into, paid child support in reliance on that. So the victim, at least for this form of restitution, is not going to be a minor. It's going to be, well, it could be a minor, but it's going to be the parent in this situation, the non-parent who paid child support as a parent.
Representative Garrett.
Okay, thank you.
Any other questions for legal? Seeing none, we're going back into session. Any other questions for Representative Parkinson? Questions been called? Any objection? Seeing none, we'll be voting on, well, I'll put my finger over here. House Bill 2780. All those in favor say aye. Aye. All those opposed? So House Bill 2780 will move out, as amended, will move out to civil full.
Thank you, Madam Chair. Thank you, committee. Thank you.
So number 11, House Bill 2945 by Representative Grills is rolled 1 week. So that moves.
All right, members, that brings us to item 13, House Bill 2169 by Chair Lady Littleton.
Motion.
Thank you. Madam Chair, you have a motion and a second. Looks like there may be two amendments here.
I want to move the 14924, please.
Okay. Members, Chair Lady's asked that House Amendment 14924 be adopted. Any objection to going ahead and adopting this? Does this rewrite the bill?
It does.
Madam Chair, thank you. Members, any objection to put this amendment on? Seeing none. All in favor of adopting House Amendment 14924 to House Bill 2169, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bills amended, and you're properly recognized.
Thank you, Mr. Chairman. This enacts the Tennessee Foster and Adoptive Parent Protection Act, which prohibits the Department of Children's Services from requiring a current or prospective adoptive or foster parent to affirm, accept, or support any government policy regarding sexual orientation or gender identity that conflicts with their own sincerely held religious or moral beliefs, and prohibits DCS from denying or precluding from consideration of parents' eligibility to foster or adopt based on their religious or moral beliefs. It clarifies that DCS may consider the religious and moral beliefs of a child of their family or of origin when determining the most appropriate placement for the child.
And thank you for that explanation. Members, do we have any questions for Chair Lady? If not, we can. Right, yes. Representative Powell, you're recognized.
Thank you. Just a quick question. So does DCS have an existing policy that was in place regarding this, or how does that, what's the existing policy or procedure they're doing?
Just to protect the foster parents or adopted parents from their of their religious beliefs or moral beliefs.
Okay. And I guess just my follow-up question is, because I think I was looking at the fiscal note on this and I saw that they had a policy. I was just curious what it was that was referenced.
Right, and members, we do have on the list, we do DCS, they're here and ready to answer any questions. We could go out of session and ask them. And we also have Jason Wilder, Jason Wilder that's asked to testify as well in opposition. So we'll need to go out of session at some point in time, but I'm at the will of the committee.
No further questions if we do that.
Very good. Members, do we want to hear from Jason Wilder? Let's go ahead and do that. Mr. Wilder, members, without objection, we're going to go out of session. Thank you. All right. Sir, if you would just sit down and be sure your red light's on there, and the microphone is, there you go. And you have 3 minutes, and we'll have unlimited times for questions. Okay, thank you.
Thank you, Chair and members of the committee. My name is There we go. Thank you, Chair and members of the committee. My name is Jace Wilder, and I am the Education Manager with Tennessee Equality Project. More so, I have worked with foster care system and fallen just outside of it whenever I was in Cheatham County. I speak today for all the kids I promised I would do my best to protect, and for the failures I witnessed in the system due to the lack of protective policies. So first, for my kids, let me tell you about a trans girl I will call A. A was a bright star who wanted to be a Christian counselor, and A was turned away from multiple foster homes due to her identity and was told that she would indoctrinate the other children. She, like 70% of other kids, were returned to her group home because of rejection of her LGBTQIA identity. She was only fostered once, and like many, also had to live in a male group home despite her identity till she was 18. I had multiple nights of trying to convince this child she was worth loving and that this wasn't her fault. This policy reestablishes to these kids that it is their fault, that they are the problem, that they are not worth loving and are not a person. This legislation only opens doors for future discrimination against kids of all backgrounds based on very loose grounds of religious and moral belief. If nothing else, I need you to understand the financial risk and impact this legislation can truly have. This year, Tennessee requested an additional $27 million to increase bed capacity and support, separate from another $156 million requested by Governor Lee. But why does this matter? This funding has guideline requirements that we must meet provided by the 14th Amendment. This includes policies that protect our kids no matter their identity, and it is a requirement from DCS to protect those with differing sexual orientations and gender identities. Again, it is already in their policy both on the state and federal level and has been for quite some time. This legislation reads, this chapter must be read in harmony with the department's duty to make placements consistent with the best interests of the child, meaning it already goes against the duty of DCS. We are risking imperative federal funds for a statement of harm. Potential foster parents and staff are trained about trauma and identity for a reason, and it's because they are often intertwined. Tennessee needs to protect these kids more, not less. This policy takes away essential protections and risks essential dollars, and that's why I ask you to vote no on HB 2169. Thank you.
And thank you for that. Members, do we have any questions for our guest? Representative Harris, you recognize.
Thank you. Thank you,
Chair. Jace, do you think that this legislation helps or hurts anyone?
Thank you. So I believe that overall that this causes more harm than good. First off, the legislation in itself already targets specifically sexual orientation and gender identity, meaning that there is already a specific group that is being disincluded that is already at a higher risk than their peers to be in the foster care system. But on top of this, it also opens up doorways for potential discrimination later on in the basis of religious and moral beliefs for many different reasons. An example of this could be a child who is Christian being forced into an atheist home and that identity being completely dismissed.
Representative Harris, any follow-up, sir?
Thank you.
Okay. Members, anyone else have any questions for our guests? Thank you, sir. Appreciate you being here. Members, do I have any questions for Department of Children's Services? I know Mr. Lyman's sitting there. Looks like Representative Powell does. Sir? While we're out of session. And you know the drill, I think. Been here a couple times. Thank you.
Good afternoon, Chairman, members of the committee. My name is Jim Lehman. Good afternoon, Chairman, members of the committee. My name is Jim Lehman. I'm the Legislative Director for the Department of Children's Services.
Very good. Representative Powell.
So if you could, I was looking at the fiscal note and it referenced a policy, or your practice, the current practice of the department. Can you speak to that of how this is traditionally handled right now?
Sure. I can speak to our position on the legislation, and apologies, I was trying to find any policies that we have in regards to, gender identity and sexual orientation and that kind of thing. And I wasn't able to find it now, but I will certainly ask our folks to see if we can provide that to the committee. Our position, we had a working with sponsor position on the legislation, but the amendment that was adopted removed any concerns that we had with the bill. The bill requires, prohibits the department from requiring current or prospective adoptive foster parents to affirm or accept or support governmental policies about sexual orientation or gender identity. Our take was that we do not do those things anyway, so we didn't, find that there was any issue with us in complying with the terms of the bill. So it was kind of where we were at on it.
Representative Powell, do you have any follow-up, sir? No? Representative Harris, you're recognized.
Thank you, Chair. And with that, there's about how many do you think, do you think LGBTYs are in DCS custody right now?
I would definitely have to get back to you on that. I do know that there are certainly kids in foster care that identify as LGBT, but I do not have the demographics on that as far as how many. But I can see if we have that. I'm not even sure we keep that information, but I can see if I can get as much information for you as we have.
Any follow-up, sir?
I'm looking at the release that came out from the White House that says protect LGBTQIA plus youth in foster care. It was an executive order policy that came out, and LGBTQIA plus youth are overrepresented in the child welfare system, somewhere about 25% of foster youth, and far too often experience trauma, including being exposed to so-called conversion therapy while in care, being placed in foster care or congregate care settings that are hostile to their identity, or lacking access to health care and mental health services to support them. The Administration for Children and Families at HHS is announcing that it will advance a rulemaking under Title 4E of the Social Security Act to protect LGBTQIA plus youth in foster care by requiring that state child welfare agencies ensure that LGBTQIA plus youth have access to a safe and appropriate placement and have access to supportive services that help to affirm them. And then almost immediately after that came out, this legislation came out. Will this affect in any way funding that DCS will receive Title 4E wise at all?
again, Representative, apologies. I'll have to get back to you on that. I think our analysis is the rule that you mentioned is a proposed rule at this point. It's not currently in effect. So our analysis was it doesn't currently impact funding. I know the rule is contentious. I know that the Attorney General, I believe, is involved in challenging that rule. So if the rule were to be effective, it may change the analysis. And I apologize that I don't know, what the impact is, but I can ask our folks, hey, if this rule administration from the federal government were to be effective and this law, state law, were to pass, what impact would that have on funding? But I just don't know. I haven't been told yet.
Representative Harris?
There actually was a policy that DCS had at one point that was on the website that I actually quoted last year. I'm going to go back and find that video. We were talking about it earlier, but I used it last year when we were talking about another bill. And it said that staff and contractors are never to suggest someone's sexual orientation or gender identity as deviant, sinful, or could or should be changed. The policy was no longer able to be found on the website now. But if we ever to find it, please let me know.
Absolutely, will do.
Very good. Members, anyone else for Mr. Lehman before we excuse him? All right. Thank you, sir. All right. Without objection, we're going to go back in session. All right. We're back on the bill. Chair Lady Littleton, members, do we have any questions? Representative Harris, you recognize?
All right. Thank you. Thank you so much. And to the sponsor, what was the genesis of this piece of legislation for you?
Senator Rose just brought it to my attention, and I agreed with it, so I just decided to run it.
Representative Harris?
And you, so do you agree with, we already have a problem getting children placed as is. Do you agree that our children should not have to feel insecure in getting placed even further than where they are now?
Chair Lady?
I think it should be a good placement with the foster parent and adoptive parent and the child.
Representative Harris?
Do you feel like if a person does not agree with someone's sexual orientation, that they should not necessarily be placed with them or to be able to uphold to whatever their beliefs are?
Chair Lady?
Thank you. I think for the child safety and the foster parent and adoptive parents to be a good fit. Yes, I agree with that.
Representative Harris?
And what do you think, where would the 25, if it is 25%, where would the 25% of those youth go if someone does not choose to accept them into their home?
Chair Lady?
Thank you, Mr. Chairman. Well, hopefully that we can find parents that agree with them, with the children.
Representative Harris, any follow-up?
Yeah, and if we're unable to do so, where will those youth go at this point?
Chair Lady?
Thank you, Mr. Chairman. Hopefully in other homes. But if it's not a good fit, we read reports every day when it's not a good fit with the parent, with the adoptive parents and the children that have extra issues, especially with religious and moral beliefs. It just doesn't work.
Representative Harris?
And if a child is adopted, is there a reversal process where that child can come back to DCS in that case?
Chair Lady?
I don't know. That answered.
Any follow-up? Yeah, and I think it goes beyond that. If I may, I think in most cases the issues that probably transpire and cause a replacement of a youth would be behavioral issues or something of that sort. I don't know that I've heard, or Chair Lady would know probably better than I. Have we ran into? I guess this is a question for the sponsor. Have we ran into many issues where we have asked for replacements of children because of how the child identifies? Because I think at the end of the day, most foster parents' hearts and minds are in the right place. They want to help kids, or they wouldn't be on the list and volunteer for that sort of position. But I guess.
Thank you, Mr. Chairman. Normally, if they do come back into custody, they're disruly and they're uncontrollable. But sometimes when the families just don't match, that causes lots of disruption and unruly children. So I don't know what the number is, but it's not a lot. but there are some that do come back. And
Representative Harris, did you have any follow-up? I kind of interrupted you.
Yeah, no follow-up for that piece of it, but we often see, and we're struggling now, where youth are having the hardest time being placed in certain homes. We did legislation last week, if I'm not mistaken, that would open up space for children who didn't want vaccine, or families who didn't want children with vaccines. And now we're doing something where now we're dipping into sexual orientation and gender, but we're just furthering the inability for a young person to be able to be placed in a home that is a happy, proper home. And I think DCS even said it just a moment ago, this doesn't necessarily change because they don't already do this. There's nothing that they do around this already. So the effectiveness of this piece of legislation and why we need it it's kind of unwarranted. It just feels more just targeted towards individuals. I think that I don't know if any people whose sexual orientation came and spoke to you and said, hey, I love this bill. Thank you for making sure I don't end up in a good home.
Chair Lady, any response?
thank you, Mr. Chairman. No one wants a child to go into a home where they're not welcomed, and no one wants a child to be mistreated. And so, but we have this is for religious and moral beliefs, and that's all.
Okay.
And I stand by that. So.
Thank you.
Mhm.
All right, and one more question. I want to move to Representative Powell. He's been patiently waiting.
And so if that is the case, if it is for a religious or moral beliefs, the sentence that says to support a policy on sexual orientation or gender identity could be taken out, because at the end of the day, if someone's religious or moral belief plays a part in there, they won't need that sentence. So it's like we're segmenting a specific section of individuals, and those individuals would be primarily those LGBTQIA youth. I just think that it feels like we are attacking a specific group of individuals, young individuals who just need a place to be placed. I would hope that we're not even, if we have individuals who have some, like you said, if they're not the right home for for a young person to go to, that we're not even looking at having them in our list of homes for folks to go to altogether.
Any follow-up?
That's just not true. Thank you, Mr. Chairman.
Thank you. Representative Powell.
I guess just a caution here is given the, the executive order that came down, I just feel like we're enacting some policies that could put us at risk of federal funds. And having been up here long enough to actually have to come back and have a special session so that we could correct a bill that was passed just to receive federal funds. I just think we're putting ourselves in a position, some of the legislation I've seen in this committee, to really jeopardize those funds. And those funds are critically important because, nothing, I think everyone agree here on this committee, nothing is more important than Tennessee children. So I just want to make that comment and would just caution the chair against advancing legislation that might risk those funds. Thank you.
Chair Lady, any follow-up?
No, thank you.
Okay, thank you. All right, members, that's all I have on the list. We ready to vote? Any objection? Seeing none. Members, we're ready to vote to send House Bill 2169 as amended to civil full. All those in favor say aye. Aye. Opposed, say no.
No.
Ayes have it. Bill moves on. And that brings us, we want to be recorded as no, see the clerk. And that brings us to item 14, House Bill 2791 by Chair Lady Littleton.
Motion.
Second.
You got a motion and a second, ma'am. And look, I'm looking at Amendment 13998.
That's correct.
Does that amendment rewrite the bill?
It does.
Okay, members, we want to go ahead and adopt that amendment. Got a motion. And any objection to adopting this amendment? Seeing none. All those in favor of adopting House Amendment 13998 to House Bill 2791, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're recognized.
Thank you, Mr. Chairman. And this bill, as amended, requires the Administrative Office of the Courts to file a report listing any juvenile courts not in compliance with the quality statewide data collection requirements to the court judge for the juvenile court not in compliance, and to the chairs of the Senate Judiciary Committee and the House Civil Justice Committee by October 1st of each year.
Thank you for that explanation. Members, any questions for the chair lady? Question's been called. Do we have any objection to vote? Seeing none. Members voting to send House Bill 2791 as amended to civil full. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill
Thank you,
moves on.
Mr. Chairman and committee.
And I believe that brings us to the conclusion of our calendar. Are we,
We're ready.
members have a motion to adjourn? Very good. And we'll see y'all next week. Thank you.
Thank
We're
you.
adjourned.